5 seconds to go. Start. In our considered opinion, the tenor of the impugned order does suggest that the division bench found the appellant to have been wronged, and regard being had thereto, the division bench ought to have set things right by interfering with the findings and granting full relief that we intend to grant to the appellant. The impugned order, insofar as it declines to interfere with the findings on the charges, being clearly indefensible, we proceed to grant relief to the appellant as indicated hereafter. The impugned order of the division bench is set aside together with the order of dismissal passed by the single judge. The order of penalty passed by the appellant's disciplinary authority also stands set aside, and the writ petition is allowed. We direct that the appellant shall be entitled to full pension without any cut. Whatever quantum has been deducted from his pension shall be returned within 3 months from date, together with interest at 6% per annum. The appeal stands allowed. We could have ended our judgment here. However, before parting, we need to dwell on one aspect. The appellant had raised a specific plea before the inquiry officer that being on the verge of retirement, election duty could not have been assigned to him. True it is, he did not produce any documentary evidence in this behalf. However, in present days, where one can access documents without much ado, we have been able to lay our hands on an order dated 7 September 2016 issued from the Office of the Election Commission of India, addressed to the Chief Secretary Punjab on the subject of general elections in Punjab, having regard to expiry of the term of the State Legislative Assembly of Punjab on 18th March 2016. Clauses 4 and 7 of the said order being extremely relevant are quoted below. In any election, very large number of employees are drafted for different type of election duty, and the Commission has no intention of massive dislocation of state machinery by massive transfers. Hence, the aforesaid transfer policy is normally not applicable to officials who are not directly connected with elections, like doctors, engineers, teachers, principals, etc. However, if there are specific complaints of political bias or prejudice against any such government officer which on inquiry are found to be substantiated, the then CEO ECI may order not only for transfer of such official but also appropriate departmental actions against him. Any officer who is due to retire within the coming 6 months will be exempted from the purview of the above mentioned directions of the Commission. Further, officers falling in category Home 3 plus criteria, if they are due to retire within 6 months, shall not be engaged for performing election duties during the elections without permission of the Commission. If indeed such is the stand of the Election Commission that inter alia doctors and officers who are due to retire within 6 months next be exempted from election duty, the letter dated 6 January 2017 of the MDPHC could not have laid down a requirement contrary to what the Election Commission ordered. In all fairness, the disciplinary authority ought not to have initiated disciplinary proceedings against the appellant on the face of such clear order of the Election Commission. The appellant is therefore quite right in contending that the disciplinary proceedings culminating in the order of penalty were nothing but a rush to wreak vengeance, for he having dragged high officials of the GOP to the High Court and in tasting success to obtain his legitimate monetary dues. The constitutional concept is that not only the country but every state in the country would be a welfare state. As the regulator and dispenser of special services and provider of a large number of benefits, none can perhaps deny that a welfare state ought to strive for achieving the maximum welfare and securing the best interests of the people. This happens to be a case where certain officials of the GOP have stooped too low to punish a senior doctor on the verge of retirement for no better reason than that he had dared to take on the mighty executive in a court of law. While depreciating such vile acts of the concerned officials, we see the need to adequately compensate the appellant. Accordingly, we direct that the appellant shall be entitled to costs assessed conservatively at Rs 50,000 to be released in his favour within the aforesaid period. Should there be any default, the appellant shall be free to bring it to our notice for appropriate direction. We grant liberty to the GOP to realize the amount of costs payable in terms hereof from the persons responsible after fixing responsibility in accordance with law. We must place on record that the respondents have not been alerted by bringing to their notice the aforesaid order of the Election Commission, and therefore, if they have their own version to place for our consideration, they shall be at liberty to approach us to have the order for costs set aside before expiry of the time limit fixed above. Stop. Before expiry of the time limit fixed above.